Shalom and welcome to On the House, the podcast where industry experts and professionals discuss real estate in Israel. I'm your host, Debbie Goldfischer, real estate agent, founder and editor-in-chief of buyitinisrael.com. Join us as we explore market trends, legal and tax issues, purchasing tips, neighborhoods throughout Israel, and much more. All this is On the House, helping you make the right move. Welcome, everybody, and thank you for joining us today for the third episode of our fourth season of On the House, where we continue our deep dive into real estate taxes in Israel. So far, we've explored the taxes due upon purchasing property, such as purchase tax, known as mas rechisha, and VAT, as well as the taxes applicable upon the sale of real estate in Israel, including capital gains tax, mas shevach, and hetel hashbacha, the improvement levy. Today, we are turning our attention to a topic that frequently comes up both for property owners and their heirs, and that is the taxes involved on inheriting real estate in Israel. For this episode, I'm excited to welcome a very special guest, an attorney with whom I work closely, who is not only an expert in real estate law in Israel, but also inheritance law. Amira Solow is a bilingual attorney specializing in both fields who dedicates a significant portion of her practice to wills and estate planning. She's also a registered notary and is certified to draft enduring powers of attorney. Amira established Solow Law offices in 2015, where she works with a wide range of clients, many of whom are Israeli residents. Amira is well known for providing warm, personal service and is dedicated to making the process as smooth as possible for all her clients. From personal experience, I can say that no question or request ever goes unanswered. So with that, welcome Amira, and thank you for joining us today on the show.
Thank you, Debbie. I'm so excited to be here on your show and looking forward to discussing everything to do with wills, estate, and tax planning.
Thank you, Amira. It's a pleasure to have you. Before we talk about inheritance, why don't you tell us a little bit about your office and what you're seeing during these very complex and challenging days?
Okay, so definitely the last 10 months have had quite an impact on everyone and anyone who had to go and serve in the army, then also a very large interest in buying in real estate. So I would say from the beginning, when so many of my clients and young families had to send the fathers into Gaza, into fighting, into Miluim, many of them got very worried and actually called me from battle, from out in Jeep saying, can I draft a will? Can I just say something to you on the phone? Obviously, a will has to be done properly, has to be in writing. There's certain requirements by law for a document to be considered a valid legal will. But people got very nervous about the situation and wanted to make sure they had wills set in place, especially families with young children. Beyond that, I've been involved in several trips to the U.S. Many people started buying in Israel in various projects, whether already built secondhand or new projects that will only be ready in 3, 4, 5 years. Everyone sort of wants to have a piece in the land of Israel. That's seeing a lot of that.
Sure. We're seeing that, a lot of that, and all of our guests that come on seem to repeat the same scenario, the same experiences. But what you're saying about the chayalim, about the soldiers who are requesting to help you write a will is something that we haven't heard before. And we hope and daven that these wills will not have to be used.
100%. I would say that I have different people that approach me in order to prepare wills. There's the older crowd sort of thinking about the actual end of their days. We're all going to die one day. Sooner or later, that's part of the world. We obviously hope that everyone will live a full, happy, healthy life till 120.
Amen.
But we all will die. We will need a will. So there are the people already thinking and planning about the end of their life. And there are young couples and young families that need to talk about, God forbid, what happens. There are so many unfortunate situations, sicknesses, accidents, God forbid, so many things. So instead of sort of coming to that type of scenario with no preparation whatsoever, and then a family not only is struck by devastating news, but then has to deal with all the bureaucratic problems when not having a will in place, better to be prepared in advance. I could tell you about myself. I signed my first will when I was 24 and had a child.
Really?
And we thought, this is the time. We have to think about the future. Write it, put it away, and hope. I would say, Here, b'sha tova, hopefully you never need it till 120 or till
So
you want to
sensible.
update it.
Wow. So the purpose of this conversation today is a combination of real estate and estate planning. And as I said, I think very carefully about the guests that I want to bring onto my show. And when I thought about the combination of real estate with estate planning, you were the first person that came to mind because I know that you are very heavily involved in both of these aspects. And as we're going to hear, there is a tremendous overlap between the two subject matters. So before we dive in, I have to apologize that I'm a little bit hoarse today. I've lost my voice. So I hope my listeners and I hope you can understand what I'm trying to say. So let's start off, Mira, from the perspective of somebody who owns property in Israel. What happens when the owner of the property passes away if they haven't left any instructions?
Okay, so in Israel, we have the inheritance law. It's called Chok HaYerusha, which determines what happens with someone's estate when they don't have a will in place. And according to the law, there are different scenarios, whether someone's married or not married. But if we would take the typical scenario where there is a husband and a wife and a few children, whether they're minors or not, according to the law, when someone dies, their spouse gets half the estate, and the other half is divided up between the children. So, for example, if a couple owns a real estate property, a house jointly, and let's say, God forbid, the husband dies, he owns 50%. 50% of that will go to the wife. So now the wife will own 75% of the house, and the remaining quarter, the 25%, will be divided up between their children.
Okay, so that's in the event that no instructions were left.
Correct.
Okay. What happens if there is not a wife and children?
Okay, so depending on the situation, if someone has children, their heirs, according to the law, would be their children if there's no spouse. If there are no children, it goes to the next in kin, the parents, the siblings. Depending on the scenario, the closest relatives become the heirs of that person.
So now let's talk about planning. Most people would want their estate to be left to people that they choose. So can you share any advice for current property owners in Israel who want to ensure a smooth inheritance process for their heirs?
Sure. So to continue from my previous example, first of all, if such a family with minor children didn't have a will in place, suddenly you have minors as owners of a property, which is very catastrophic. The remaining spouse can't just sell the house without court's approval, putting the children's share in a trust for them. So one would want to sign a will where they leave the entirety of their estate to their spouse. Usually a husband wants everything to go to the wife goes everything to the husband. And only if in the event when they're both deceased, then it should go equally between the children. That's sort of a typical scenario, but there are a lot of different other things one can do. For example, if you have children who are adults, maybe you help them with higher education. Maybe you help them to buy a house. So maybe you want to give the child who didn't get any assistance a little more in the will. You can do all of that. If you have physical belongings such as specific jewelry or any candlesticks and you want to leave them to specific children or maybe to parents, siblings, friends, whatever you want, you can do all of that within the framework of the will.
Okay, so let's talk about the process or the requirements that somebody has to fulfill in order to set out these instructions in a will.
In order for a will to be valid, the typical sort of will
Valid in Israel.
It's not only valid in Israel, it could be valid for other countries.
Okay.
Some people sign a will in Israel that applies to their assets all over the world.
Really?
You can have multiple wills. I have clients in the States, for example, who have wills where the beneficiaries are trusts. They're very large on trusts in the States, not so much in Israel. So sometimes they'll want to have a separate will in Israel just for their Israeli assets. It's easier to probate it also later on. But one can have a will in Israel that applies to the assets all over the world, whether you have a bank account in the States or Canada or Australia, or you don't have to have it only for Israel.
Okay, so you were saying, so in order for a will to be valid?
Okay, so in order for a will to be valid, it has to be in writing, dated, signed by the testator in front of two valid witnesses who are not related to him and are both over 18.
Okay.
It's called tzava'ah b'chtaviyah, tzava'ah b'fnei edim. There are other types of wills. There's a will that you can sign in front of a notary, and then a notary can notarize the will. It doesn't have to be in front of two witnesses. A will can be deposited with a register of inheritance. You don't have to do this. And one of the things I'm sure you'll be asking me, a will, you can update it at any time without limitations. So sometimes depositing the will with a register causes a little more bureaucratic annoyance, I would say, but
Does it have to be registered? Does it have to be deposited with
it does not have to be deposited. You can sign a will, you can
put it away?
have several copies. Usually you keep one copy in your safe or wherever you keep your important documents. Usually your lawyer will save a copy, and then you can have additional copies. Give it to your heirs, give it to whoever you appointed as a trustee. At any given time, you can update that will, and the new will cancel the previous will, making it null and void.
Understood. So as a lawyer, what is your role in this?
I draft the document. Now, I know some people ask me, oh, I found something on the internet, and so I just signed it. Is that a valid will? The answer is it could be a valid will as long as one signed it, dated it in front of two valid witnesses. Is it a good will? I don't know. You want to use a lawyer who is an expert in wills and estate planning to make sure that the will is drafted properly. Otherwise, if it's vague, if it's unclear, it can be invalidated. It could not be probated as one would want later on.
So are there any special documents or legal procedures that people should be aware of when they're writing their will?
I always recommend for people, make a list of your assets. You want to provide it to your heirs just to make sure that they never lose these assets. For example, if they have investments overseas, could be that the heirs don't know about it. So make a list. You don't have to include the list with the will, but make sure your heirs are aware of it. If you have children under 18, you may want to instruct who you'd like to be the guardian of such a child. And ultimately, the final decision is the family court, but the parents can put their wishes into the will as to who would be the guardian of the children, taking into account that usually children who are living in Israel and have their life here, the courts here would prefer to find guardians who are living in Israel and not sort of ship them off to the States to live with the grandparents.
Sure. Okay. These are conversations that are difficult to have, I'm sure, and very hard for all the parties involved, but very, very important.
Exactly.
So now if we zoom in and focus specifically on the real estate side of the estate, what are the tax implications on the inheritance of real estate, and how does this impact the planning?
In general, in Israel, there is no inheritance tax. So if parents leave their assets to their children, the assets will move to their children without any tax implication.
We're talking about real estate in Israel?
Real estate in Israel, bank accounts.
What about real estate outside of Israel?
Those would be taxed according to that country where they're at. So if you have, let's say, a house in the UK, and the UK does have inheritance tax, as far as I know, you could be taxed there for the assets that you will inherit there.
Okay, so we're focusing now on real estate in Israel.
In Israel.
If somebody inherits property in Israel, there is no inheritance tax.
Correct.
Okay.
So then that asset will be eventually registered in the name of the heirs. But when does the tax planning come into effect? If the heirs want to sell that property. And that's when it's very important.
Is there any mas rechisha on the inheritance?
No, because as I said, because they're bequeathing the asset to the heirs, the heirs are receiving it as an inheritance. As a Yerusha, there's no tax. They didn't purchase it. They inherited it. Okay. And there's no inheritance tax.
But they now are the owners of a property. So if they come to buy property, they're now considered to be owners of some additional property.
They are protected because if, let's say, a young couple inherited an apartment from their parents, but now are coming to buy their own, having up to 50% of an apartment that was inherited does not take away from their rights and their tax benefits of buying an only apartment. For inheritance properties, it's up to 50%. We could check, it always changes. But as opposed to a different scenario when you owned up to like 33%, a third of a property, doesn't take away from your tax benefits.
So if you bought a property together with two other partners, if you purchased it, you have up to 33%. But if you inherited a property, you have up to 50% to be exempt from the purchase tax.
Correct. I would always say check it again because the tax laws are constantly evolving and changing. So just make sure that that didn't change.
Sure. Okay. So those are the tax implications when the property is inherited. What about, as you were saying, the sale of the property? The heirs have decided they don't want to hold on to the property. They want to sell it and enjoy the proceeds. What are the tax implications?
Okay, so this is where the planning of the estate and the will is very important. If a couple owned one property only, they owned it for more than 18 months, and they're Israeli residents, if they were to sell that property while being alive, they would have an exemption of capital gains tax up to about 5 million shekel. That exemption is inherited to their children. If their children are Israeli residents, doesn't matter if they own their own properties or many properties. If they inherited an asset, a real estate property that was owned by the parents and that was their only property, they can sell that property using an exemption of capital gains tax. It's a specific inheritance exemption.
Okay. And if it was not their only property?
Then on the sale of that property, they would have to pay capital gains tax. And the calculation is done from the time that the parents bought the apartment. So if they owned it for 20 years, we're going back now 20 years. We're not looking at how much it's valued at the time of the death when the property is transferred. We have to go back and do a full calculation. However, if parents own several properties, for example, they can bequeath each property to a child. If that child didn't own other properties, that property then they could sell with an exemption. Obviously, they would have to own it for a while.
So on the one hand, you're saying that they look at how many properties the parents owned. If the parents only owned one property, then there is an exemption. If the parents owned more than one property, then they have to pay capital gains tax on it, unless the children don't own a property?
On the sale of the property, then they don't have an inheritance capital gains tax exemption. But if the child himself, obviously over 18, sells the property and he himself has an exemption, then it's his own capital gains tax exemption, not the parents.
Understood. Okay. So it's interesting that they can look at both the parents' status and the child's status as well. Now, what if there are minor children involved?
So the minor children would have guardians, and if they're the heirs of this property, the property will be registered in their names and sort of either wait till they're over 18 to make any transactions, or the guardian, the trustee, would be able to have a transaction done in their name, but it would have to go through court.
I see.
There's a process called ishur peulat katin, which is the confirmation, the approval of a transaction done in the name of a minor.
So the transaction can be done, but it's obviously more complicated.
It's very complicated. I also wanted to mention that many parents who have several properties sort of plan their wills and plan their estate planning in advance while they're alive. If they own several properties, some of them will gift some of the properties while they're alive in order to remain with only one property for the inheritance. Mm-hmm. So sometimes I'll have clients who'll come to me and say, I want to gift this apartment to my daughter who doesn't own anything, and then leave the remaining one property into their inheritance.
That's very interesting. So that just reinforces the importance of planning and thinking ahead.
100%.
Okay, what happens when somebody, God forbid, passes away and the heirs are notified that they have inherited a property? What do they do?
Usually they would contact a lawyer and start the process of probating the will. In order to do that, one of the documents one would need is the death certificate, which is supplied and issued by the Ministry of Interior. We would need the original copy of the will. If one cannot find an original copy, there are ways around it. There are applications to send in to prove a will by a copy. But that's why I always recommend to sign several copies, even if someone loses it or, God forbid, there's a fire. Mm-hmm. There should be an original copy. It's much easier to probate a will when you have the original will. One of the heirs would be the person signing on the application to probate the will. We send it in. Now it's all through an automated online system. Every lawyer has sort of a smart card, and then we can submit it directly to the Register of Inheritance after signing the heirs on whatever documents necessary. And then there's a time period where they publish the notifying that so-and-so passed away, and an application for an order of probate has been requested, giving the opportunity for anyone who wants to contest the will.
Where is this published?
It's called the Rashumot. It's in the official government. No one really looks at it. I don't know anyone who ever looked into it. And
find out what else is due to you.
But, obviously one would have to notify all the heirs involved. Mm-hmm. And then usually a few months later, we would get the order of probate. So if there are minors involved as heirs, then it's complicated and it goes through the court. In a sort of typical, simple scenario, one would get the order of probate in a couple of months. Complicated wills, where, for example, the person who left the will died overseas or their will is from overseas, it's always more complicated. You would have to bring a legal opinion of a lawyer who's certified in the country where the will was drafted and signed or where the testator passed away. Sometimes it goes then to the family court to get their response to the request. Sometimes it can take a very long time.
So this is really important because many of our listeners are from overseas and they're buying property in Israel. And for the time being, they're not living in Israel. So what would you recommend they do in order to minimize these issues?
And the complications and the bureaucracy. This is exactly, I had a client last week. I represented him a couple years ago in buying a property in Jerusalem. It's now built and ready. And he said, listen, I want to have a will in Israel for my bank accounts and my apartment. No problem. He's coming in to Israel in the next couple of weeks. I'm preparing the wills, emailing them, we're drafting them. Once it's all agreed, I'll meet them in Israel and sign them on a will for their Israeli assets.
I see. So does this override their will in America? Or is it?
It coexists. It coexists. And not only that, specifically, he wanted to mention his American will within the framework of his Israeli will. One can say, this will applies to my assets in Israel solely. I have another will in the States for my assets there. You don't have to write that in the will. But if you have a will in Israel for your Israeli assets, you submit that will only to the Register of Inheritance. You don't even need to mention your American will. And in America,
it makes your life so much easier, right?
It's much easier.
So as a real estate lawyer, I mean, do you offer this? When people buy real estate, do you say, would you like to put it in a will?
You know, once they get the apartment, I say you should have a will in place for your assets
so
here.
Smart.
Yeah, and it's sort of, the cost isn't tremendous.
Sure.
And it saves so much bureaucracy and hardship later on having to deal with probating overseas wills here.
For sure. So, and what happens, Amira, if somebody inherits a property and let's just say it's a parent and they never get around to doing the paperwork? They just leave it in their mother's name, their late mother's name. They carry on using the apartment for vacations or whatever. How does that ever, what issues can that cause? And is it resolvable down the line?
So people do this all the time. It definitely causes complications down the line because maybe then the heirs pass away. But of course, there are ways to fix it down the line. We've had wills, sort of very complicated cases where for years it was on our desk because some grandparent in 1940 bought an apartment and then slowly, went to this area. You had to identify and you slowly go down the line, probating everyone's estate, proving who the children are, etc. There are ways, but it's very complicated and it will cost a lot of money, even in legal fees, trying to identify and preparing all the paperwork. So definitely, if you have a will, go and probate it, put it in the name of the heir. It will only solve it, make it much easier for the future.
I can hear the takeaway from this is that the earlier on that you do these things and the help that you get in doing so is critical because it saves so much time, money, and heartache down the line.
Exactly. I would say you don't have to hurry as much as I had a client who, while in Shiva, came to me to start the process. But of course, I helped her. But, she came for a short time. She wanted to start dealing with it. So definitely better to deal with it sooner rather than let it drag on for years and then have various complications.
Sure. Now, going back to people who are overseas. So somebody who's, let's say, in the U.S. who finds out that they have inherited a property. Is there anything different that they have to do from an Israeli who's living in Israel?
Obviously, they would have to hire someone here to represent them, fill in all the paperwork. If they're the sole owner, for example, the sole heir of this property, they'll have to have someone represent them in applying for the order of probate and registering whatever assets
And that's something that you can do, obviously,
yes,
as a lawyer, right? I'd also say that they have to bring in, if they want to sell the property, they should bring in a shamai, an appraiser.
If you're going to sell it, then yes, bring in an appraiser, bring in a realtor, start the process of selling it. But initially, I would say, first of all, put the property in your name. You asked me before what happens with people who don't take care of it right away. Very often, over the years, I've been doing real estate for 20 years, we've had people who said, oh, I have an apartment and I want to sell it. They bring in a realtor and they say, okay, they find a buyer. And suddenly we find out that it's not even registered in their name. Now they have a buyer on the line, but nothing to prove that they are actually the owners.
And it can completely stall the whole transaction.
It could be months to get it registered in their name.
In which case they can lose them. They can lose the deal.
They can lose the deal.
I guess that's also applicable to when you're renting a property. You want to make sure that the rental is registered in the name of the people who are representing it.
So I would say yes, except as a renter, it's not as crucial. If
Sure.
you're renting it from the son of the owner, for example, some people own properties and have their children deal with all the checks and the payments. As long as you're living in it, you're using the apartment, you're fine. You're not owning it, you're not buying it. So if something happens, you just sort of take your checks and leave. But what I do see sometimes, I actually have a deal on my desk right now. These people found an apartment, they loved it. I contacted the lawyer, she checked, and the original owner who represented the seller never finalized the registration in their name. So now that's exactly stalling the deal. We want to wait to see it registered. Same goes for an inheritance that wasn't registered in time.
Mm-hmm. And what about when there are multiple heirs and one wants to sell, the other doesn't want to sell? It just makes things more complicated.
That could be a complication regardless. If there are 5 children, they all are now owners of 1/5 of an apartment and they don't agree with what to do with, they might end up going to court. If 2 want to sell and 3 don't want to, or whatever it is, can't force each other unless you go to court.
Sure. Amira, what happens if there are no children? There's no next of kin to whom to leave the property to, unfortunately, and somebody decides they want to bequeath their real estate to a charity organization. How does this impact things?
Sure. So I've had various clients over the years who decided to bequeath their assets, whether it's to distant relatives or sometimes even a family friend that took care of them, or to different charities. I've seen people write 10% to this charity, 20% to that charity. I've seen various situations like that. It's always important to write the organization number. So if it's an amuta number, so it's clear who you're leaving it to.
Amuta is, how do you define an amuta?
A non-profit organization.
Okay.
It could be, some people leave it to shuls, which is also would probably have a non-for-profit organization number.
But for all intents and purposes, it's the same process as leaving it to individuals.
Yes. Then they would register the assets in the name of that heir, whether it's an individual or an organization.
And what the organization then does with the real estate is a whole nother topic of discussion.
Whatever they do, obviously they, depending on the organization or the identity of the heir, maybe they have exemptions in sale of the property or not, but that's something else to discuss. Yeah.
Okay. Also, I was thinking from a halachic perspective, is there anything that needs to be added? I know when it comes to Jewish law, there's so many details and halachot that impact the inheritance and the writing of a will. Can you tell us how this would impact the work that you do?
Yeah, so I actually, when someone approaches me to prepare a will, I sort of send a checklist, a list of questions. And one of the things that I offer is, are you interested in a halachic clause? What is an halachic clause? According to the Jewish inheritance laws, if you have an oldest son, a bechor, he gets double the Yerusha. But in your will, you want to inherit it equally between your children. One can add a clause that says basically everything I'm giving and dividing under this will, I'm giving so as a gift 1 hour before my death. So you're not actually going against the Jewish laws of inheritance.
Interesting.
You can put such a clause. I know that there are rabbis who prepare whole halachic supplements to wills, long documents. There are things about kinyan that one can do. So there are solutions. Everyone could choose whatever is good for their own needs and wishes.
Okay. Now, you touched earlier on something which is very important. That is the updates of wills. So if somebody has a will they wrote 20, 25 years ago, and now they want to update it, what do they have to do?
It's very easy to update a will. It doesn't have to be 20 years. I call my client a serial will changer because she likes to update her will quite often. But there's no problem. You just update the will. As long as you signed it with a new date in front of 2 valid witnesses, the new will becomes the new valid will that nullifies the previous will, whether it was 20 years ago or 2 months ago.
And what if someone stipulated in a will, let's say regarding a property, but the property was sold and nobody updated the will?
The will applies to the assets that one owns at the time of their death.
Okay.
And usually I'll specify including my apartment in this location. If since I signed the will, I sold that property and I bought another property. The old property is no longer included
It's
in the
not
will. It's not
relevant.
mine. It's not part of my estate.
Not
The
relevant.
new property will be included in my will because it's part of my estate.
Got it. And a will, you said, has to be signed in person. It has to be written. Can it be done digitally today? Can it be saved on a cloud? Can it be signed on a Zoom call, on a virtual video call?
It's not so difficult to sign a will in front of two valid witnesses.
Sure.
You don't have to sign it in front of the lawyer, by the way. I've prepared wills for people who either lived very far away or even in the States. I can send them to the consulate or in front of a notary there.
But it has to be done in
It
person.
has to be done in writing. Not only that, in order for a will to be valid, the person signing the will has to be of legal capacity. So if I have an older client, for example, over a certain age, sometimes I'll ask for a doctor's letter on the day that I sign them on the will, confirming that they checked them and they're cognitive, they know what they're doing, they legally understand that they're signing a legally binding document.
And if they cannot do that, then
I will not sign. I will
then we
not
default
witness.
back to our initial conversation about what happens when there is no will.
When there's no will or if they have a previous will. But I will not sign anyone on a will unless I have recognized that they know what they're doing and they understand.
Okay. Is there anything else that you would like to add to this conversation before we close?
Sure. So I've had different people come to me. Sometimes people in second marriages, it's very important. If someone's divorced or a widow and they're remarrying, it's important to have a will in place before they get married that determines what happens with their assets. In addition,
Especially if they're grown children.
grown or minor doesn't even make a difference, but one should have a prenup in place to determine, who owns what. What did they say when someone sort of enters perek bet, what we call in Israel, second chapter, one should have a prenup and a will. If you want to leave your assets only to your children, make sure that your will states that. And then whether you're married or not, your will supersede the marriage and make sure that your children are the heirs of your assets. I would like to add another type of will. It's called a mutual will, which is almost like an agreement. Husband and wife can sign, you each sign a separate will. Sometimes a husband and wife will have sort of identical wills or what we call mirror wills. I leave everything to you, you leave everything to me, we leave everything to the children after that.
Perfectly symmetrical.
Symmetrical. Sometimes it's different. Sometimes the wife will include that her rings go to this daughter and that goes to that son. But there's another type of a will called a mutual will, which basically binds both people signing the will so they cannot change the will after the death of the second spouse unless you go through a certain process, basically to protect the children. In a case where someone remarries and maybe leaves everything to the new spouse or to their children and maybe leaves their own children out. So it's clever, but it's also limiting. So I don't always recommend it. I always tell people there is an option of doing this mutual will. And depending on their situation and their family status, is it appropriate for them or should they just do the regular will?
Amira, this has been a really helpful and important conversation. You started out by saying, we're all going to die one day. I remember once hearing that nothing in this world is certain except for one thing, and that's death. Unfortunately, we're all going to die. We don't know when, and we have to prepare. And as parents and as adults, we have to take responsibility and plan accordingly. And real estate really is the biggest asset. Real estate and property, biggest assets that we own, and we must prepare accordingly to leave them to our loved ones and to the people that we want to take them over. So thank you so much for joining us. And before we end, I have two very important questions. The first is, where in Israel do you live and what do you love about it?
So I'll just start by saying, first of all, that when I do sign families, couples, people on will, I'll always end it by handing it over and wishing them a good, healthy, long life. So that's what I am wishing to everyone as well. And especially during these times, wishing all our soldiers to come back healthy and all your listeners as well. I live in Modi'in. I absolutely love this city. I've been here for 17 years. I would say my favorite thing is the community. I'm part of an amazing community.
We're part of the same community.
Love our community, whether it's the initiatives that the shul has taken or the lectures or the shiurim or just the amount of help that I've seen coming out of our community over the last 10 months and different opportunities that I had to help the situation in the country was amazing, and I really love it.
So true. If you were to move somewhere else in the country, where would you go and why?
Wow. I love the beach. I love the ocean. So definitely somewhere with a beach view, with a sea view. I would say not Tel Aviv. It's too Tel Aviv. Maybe Caesarea, Netanya,
Beautiful,
somewhere nice
beautiful.
like that.
Up in the Sharon area. Very nice. Okay, Bezrat Hashem, your dream shall be fulfilled and you should be able to enjoy the beach.
Thank you so much
Okay.
for having me, Debbie. This was an actual pleasure, and I love discussing everything with you.
Thank you. Thank you so much, Amira, and thank you for everybody for listening. And at this point in time, it is appropriate to wish everybody a Shana Tova, and we should all be inscribed for the Book of Life for healthy, happy, peaceful days here in Eretz Yisrael and around the world for all of the Jews. And we should, please God, see, if we haven't seen by the time this recording comes out, we should see the ultimate redemption. All of our chatofim, all of the hostages should come home safe and healthy, and all of our chayalim should be safe, and we should restore peace and security to our borders.
Amen, amen, amen.
Thank you again, and Shana Tova.
Shana Tova.
Thank you for listening to On the House. If you enjoyed this episode, make sure to subscribe and share it with your family and friends. You can also visit buyitinisrael.com, where you can find news, market updates, guidance, and much more on real estate in Israel. That's Buy It in Israel, BUYIT in Israel.com. If you have a question or a specific topic you'd like us to cover on this podcast, please email us at the address you'll find at the bottom of the show notes. Whether you're thinking about Aliyah, looking for a home or a haven, or wanting to support the Israeli economy, now is the time to buy it in Israel.